Welcome to Transnational Competition Law course, and dear learner and viewer, today we are going to discuss the enforcement of the extraterritorial application of the competition law and the transnational application of the competition law in India in reference to Section 32 and Section 36 of the Competition Act vis-a-vis the overarching power of the Competition Commission of India in regard to having inquiry, investigation, and passing any kind of the order which serves the end of the justice in matters of competition dispute, and the competition's omnibus power to pass any kind of the order which is deemed necessary, expedient, and fit to serve the cause of sustenance and maintenance and restoration of competition in the Indian market, and as well as to keep Indian market from any kind of an appreciable adverse effect on the Indian market by any kind of activity such as the anti-competitive behavior, regulation of combination, merger and amalgamation, abuse of dominance, and cartelization. Now, what we have seen that there is a complete set and wide range of the statutory provisions and the functions and the powers and the ambit of the Competition Commission of India is well established and recognized and thrashed out by its establishment in a large number of cases. But today what we are going to discuss that whatever is the procedure which is going to be adopted by the Competition Commission of India, be that the guidance and supervision of the basic canons of the natural justice, or be that adoption of the Civil Procedure Code of 1908, or be that the adoption of the Competition Commission of India General Regulation 2009 in matters of deciding the competition disputes in India. Today, dear learner, we are focusing on the point as to how the decision which has been taken by the Competition Commission of India on the extent of Section 32 and Section 36 of the Competition Act, how it is going to be enforced and how it is going to be executed. So today what we will be discussing is in fact the Competition Commission of India's competencies and core competency in matters of the enforcement and execution of its own order in relation to curb all kinds of competition concern, all kinds of antitrust violation, and all kinds of anti-competitive behavior. To this end, what we see again, we have to go to Section 32 and Section 36. What we find that prior to 2007 Competition Amendment Act, there was no provision in regard to the enforcement or the clear-cut direction about the procedure, but the Competition Commission, the Competition Act 2007 has not only been able to create the Competition Commission of India, but have given enormous power to give effect to extraterritorial jurisdiction under Section 32 of the Competition Act. And but the enforcement of the Competition Act, looking from that point of view, what we find that the enforcement issue is something very central to the entire spectrum of the extraterritorial application of the competition law. We have seen very categorically that Competition Commission of India had not only power to inquire into all kind of the agreement which are known as to abuse of dominant position or combination of such agreement, or having likely to cause an appreciable adverse effect in the relevant market of India. But what we see that the Competition Commission of India is now not only having the power to inquire into anti-competitive practices, but also pass such order which it deems fit, expedient, and necessary. Now, with this, we find that in matters of the power of inquiry by the Competition Commission of India, we have seen and we have to peruse very carefully Section 19, Section 20, Section 26, Section 29, and Section 30 of the Act, which deals that the entire procedural wrangle, entire the procedural panoply of how things which have been mentioned under Section 3, Section 4, Section 5, and Section 6 of the Competition Act are going to be enforced by the Commission. And here, the Commission finds that there is no contravention of the provision of any act, then it shall approve by order such agreement or combination. But in case of application of Section 3, Section 4, Section 5, and Section 6, vis-a-vis Section 19, Section 20, Section 26, to Section 29, and Section 30, if the Competition Commission of India finds that there exists some kind of the anti-competitive agreement or abuse of dominance or combination which causes or likely to cause an appreciable adverse effect on the relevant Indian market, then it shall direct the person or enterprise or group of person or enterprise to discontinue and not to re-enter such agreement or abuse of dominant position, irrespective of the fact that the consent act has been taken place outside India. It will exercise its jurisdictions and will try to see that the law must be enforced in the right earnest. So in that way, we see that not only Section 32 is important, not only the Section 36 is important as to what we will apply in the entire procedure of the application of the Competition Commission of India, be that the established canons of justice, be that the Civil Procedure Code, or be that the Competition Commission of India General Regulation 2009. But we have to very carefully see as to what has been contained in Section 27 and Section 31 of the Competition Act, which tries to give a clear indication that the order passed by the Competition Commission of India and the enforcement and execution of the orders of the Competition Commission of India should possess some very meaningful remedies, and those remedies and those remedial aspects and the ambit and scope of those remedies are to be understood in the context of Section 27 and Section 37 of the Competition Act, which says that the Competition Commission of India, after the completion of an inquiry procedure, will certainly advance remedial measure. So, what is important in the enforcement of extraterritorial application of the competition law or the enforcement of the transnational competition law is primarily the fact that what is the range of the competition remedies. That is something very important, that what concrete and cogent remedies are going to be passed by the Competition Commission of India. In that respect, we have to look at Section 27, and Section 27 very categorically talks about the order by the Commission after inquiry into agreement or abuse of dominant position, whereas Section 31 talks about the orders of the Commission on certain combination. So the nature of the order, nature of the remedies also remains one of the pertinent issue while we are discussing the transnational application of competition law or extraterritorial application of the competition law. Having understood the entire procedural wrangles of the application of extraterritorial application of the competition law and as well as the transnational competition law, now it appears very apt to not only concentrate on Section 32 and 36 and then Section 27 and Section 31 from the standpoint of the advancement of remedies by the Competition Commission of India. We have to see the actual process which has been which has been laid down under Section 32 vis-a-vis Section 27 vis-a-vis Section 31 of the Competition Act under Chapter 6 of the Competition Act. And then we find that a perusal of all these sections reveals that the Competition Commission of India, in order to see that its order, its judgment, its verdict is to be observed and in compliance, and for ensuring the compliance of all the order which is to be passed, meaning thereby the one aspect is the enforcement and another aspect is the very process. Another aspect happens to be the enforcement of the remedies, enforcement of the order, enforcement of the remedies. From both the point of view, we have to again have a fresh look in the interplay of section 32, 27 and 31 to just to understand that how we can bring more compliance to the order passed by the Competition Commission of India from the point of view of the enforcement and compliance. And in this respect, what we find, what we generally find, that the Competition Commission of India does, if the orders of the Competition Commission of India is not complied with, then what are the options which are open? That is also very important. Otherwise, that the orders of the Competition Commission of India will always remain a paper tiger, or it will be observed in breach but not in compliance. From that point of view, what we find, that there is a provision of having penalty to be imposed, and then we see that section 39 of the Competition Act is very categoric, that as we find a combined perusal of section 32, 27 and 31, that in order to effectuate, in order to enforce, in order to execute the Competition Commission of India, its own order can impose certain penalties, but section 39 happens to be a guide in that reference, which talks about that how we can recover that penalties which are going to be imposed in matters of non-compliance or execution and the enforcement of Competition Commission of India's order. In that respect, we see that section 39 is very important, which talks about the recovery of the penalty, and for that, what kind of regulations are there for recovery of the penalty and for the enforcement of its order. Then again, we have to go to the methods and methodology which is being adopted by the Civil Procedure Code of 1908, that for matter of execution of any order, any decree, how it is to be recovered, and the recovery of the penalty should follow the areas of land revenue, or what as contained in the Civil Procedure Code, or it should be governed by the para 2 of section 39, which talks about that the recovery of the penalty in case of non-compliance of the orders of the Competition Commission of India will be done through the Income Tax Act of 1961, and in that respects, that the penalty are to be recovered as a tax dues under the Income Tax Act of 1961. Therefore, what we see, that section 39 is very important in matters of the enforcement of the orders of the Competition Commission of India, and some kind of a prosecutorial strategy, some kinds of recovery, imposition of the penalty, and as well as the recovery of the penalty is something very important to see, that the orders of the Competition Commission of India should not be defied. In that respect, we will be referring to a case law on the point, and that case law pertains to the year 2022 and the name of the case is Meta Platform Incorporation versus Competition Commission of India. And in this case, to further see and reflect upon the powers and functions of the Competition Commission of India in matters of the transnational application of the competition law, and as well as the extraterritorial application of the competition law, we see that in this case, that in suo motu, cognizance were taken by the Competition Commission of India in regard to the updated terms of service and the privacy policy for the WhatsApp user. And then in the impugned order is try to understand that what is the market for OTT messaging app through the smartphone in India, and the whole issue is being covered under Section 4 of the Competition Act. And then the case went to the Delhi High Court before the single judge bench. That order was challenged by the WhatsApp and Meta through the writ petition, and the High Court happens to deliver its final verdict in 2021, rejected the contention raised by the WhatsApp and Facebook in regard to the violation of Section 4 of the Competition Act. Then the case again went to the division bench of the Delhi High Court, and Delhi High Court, while perusing that judgment of the single judge bench, reached to the decision that and concluded that the courts is of the opinion that the impugned judgment of the single judge bench dated 24th April 2021, passed by the learned judge, is a well reasoned decision, and the appellant are devoid of any merit and substance that would warrant an interference by the division bench of the court, and it was dismissed. The case again went to the Supreme Court of India, and the Supreme Court of India had an occasion through this case to examine the power and function of the Competition Commission of India and the power of and functions of the Competition Commission of India in regard to what you call the suo motu cognizance, or the power that it can take any action which it deems necessary and fit. Then the Supreme Court has observed very categorically that the Competition Commission of India is an independent authority to consider any violation of the provisions of the Competition Act 2002, and when having a prima facie opined that it is a case of violation of the provision of Section 4 of the Competition Act, and thereafter, when the proceedings are initiated by the Competition Commission of India, it cannot be said that the same are wholly without jurisdiction. Thus, in another case, we'll be referring that the Competition Commission of India have that power, and Supreme Court in case of Meta Incorporation, Meta Platform Incorporation versus Competition Commission of India 2022 have upheld the powers and functions of the Competition Commission of India, meaning thereby the omnibus power to pass any order when what it deems necessary and expedient and fit in matters of the violation of the competition law. Then it also have the Supreme Court of India and the Delhi High Court single bench and Delhi High Court division bench, as well as the Supreme Court, jointly upheld the suo motu cognizance of the Competition Commission of India in reference to the updated terms of the service and the privacy policy for WhatsApp user by what you can say that the market for OTT app through the smartphone in India. This thus it can be said very with a great sense of confidence and with a great sense of certainty that Section 32, Section 36, besides that the Section 39 and as well as the Section 27 and Section 31 all happens to come to aid and advise and to come in rescue to see that the orders of the Competition Commission of India pass under Section 3, 4, 5, 6 or Section 19, 20, 26, 29 and 31 are to be observed and in compliance, and if there is no compliance, it can adopt prosecutorial strategy of realization and recovery of fine either under the Code of Civil Procedure Code or by under the Income Tax Act of 1961. With this, dear learner and viewer, I conclude my discussion on the power and functions of the Competition Commission of India in regard to the enforcement and execution of the extraterritorial application and transnational application of the competition law. And thank you very much, and I wish you a happy learning.